Good morning, ladies and gentlemen. I'm Michael Rosen. I'm a professor in the government department, and it's my brief, very pleasant duty this morning to welcome you to the main day of our conference, Office and Responsibility. I know that not all of you could come last night, but you'll know, those of you who were here, that it launched with tremendous éclat, and I, who've had the pleasure and privilege of looking at our speakers' papers in advance, I'm fully confident with the combination of those speakers and the many distinguished faces that I see around me that it's going to be equally exciting and rewarding today. We're going to start with a contribution by Nancy Rosenblum, who is going to remind us, I think is the right word, of some of the reasons that we have to be so grateful to Dennis for his work.
The thought was that I would give an introduction to the introduction to the introduction. Dennis pioneered the theme of office and responsibility in contemporary political theory, and our celebration of his contributions singles out his work in this vein. They are, of course, only a piece of his wide-ranging scholarship in democratic theory and in the history of political thought. The power and impact, I think, of the work of a great, mature scholar goes beyond subject and even beyond argument and style. It is finally, I think, a dispositional matter, a matter of intellectual and moral orientation. And so I want to say just a word about Dennis's contributions by reflecting on what I take to be the moral temper and the sort of sober political ambition behind his work, what gives it its integrity. Perhaps some of you have read Amos Oz's little book, How to Cure a Fanatic. He writes, "Who would have thought that the 20th century would be immediately followed by the 11th century?" and Oz's idea of a cure is the literary imagination, which he says inoculates us against fanaticism. The temper and aim of Dennis's work, I believe, shares this basic anxiety and this search for a cure. Now, it's true he doesn't look to art, and it's true that Dennis typically poses things positively, not defensively, in terms of principles like moral respect, to take one of the key ones. Still, in book after book, patiently, concretely, systematically, bringing disciplined attention to political situations and political science, he contemplates how we might guard against our present strains of fanaticism and extremism and uncompromisingness and zealotry and overconfidence and unreasonableness. And not just unreasonable as a term of philosophical art. That is, Dennis is not an extremist on the other side. He's not what the poet Alan Dugan talked about as being unhappily in love with reason. So my point is that underlying individual studies like ethics in Congress or political ethics or Obama's ethics agenda or secrecy, I think is Dennis's conviction that we have a responsibility to anticipate, to ward off, to protect against the strains of extremism and uncompromisingness and zealotry. And I mean the quotidian ones, as well as the dramatic ones, the ordinary ones, not just the murderous ones, the things that are, at bottom, I believe, anti-political and that damage democracy, even if not fatally. Now, there's nothing in the circumstances of politics, including stable democratic politics, that by itself is a deterrent. And Dennis has been our most persevering witness of this fact. His cure is institutions, which can, in his words, design responsibility. And the force of his ideas, I think, come from the fact that any serious institutional engineering must begin from a diagnosis of democratic weakness that's informed by political psychology. And there are many aspects of political psychology, but in particular, in Dennis's case, insight into the destructive frames of mind, fanatical or uncompromising or whatever, the mindset, to use his recent phrase, that institutions can either inhibit or contain or fail to inhibit and contain. So this, I believe, is the rawer, deeper orientation behind all of Dennis's work, and it's why I think it will continue to speak to our young but already extreme century, as it did to the last. I want to also take a minute to echo Derek Bach's observations about Dennis's institutional contributions to office and responsibility, which began, as you know, at the Safra Center, which he founded as the University Center for Ethics in the Professions, where he encouraged the view of professions as offices. And the impact has been measurable. It's been enormous, the incorporation of ethics into all kinds of professional schools and programs, as we know, and it's produced a raft of scholarship. But the question really is, why? After all manner of programs sputter, they stall, they fail to have some sort of progressive dynamic that allows them to replicate themselves, and I think the answer, of course, owes to Dennis. It owes to his genius in the way in which he formats both research and the training of young people, to the high quality of work that he always demands, and as most of us know, sometimes unwillingly, his gift for creating venues and deliberately engineering collegiality where it wouldn't otherwise exist. It also owes, of course, to a set of ideas about ethics, including office and responsibility, that because of their clarity, because of their transportability, an awful word, but we know what it means, and the sheer accessibility of the justifications that he provides, have really shaped practical understanding. Let me make one last observation. Dennis enacted responsible office holding as an institution builder and administrator here at Harvard, and his stints as a counselor and consultant to executive and congressional committees on ethics represent a kind of seamless move from academic diagnostician to public teacher and advocate. It's no accident that Dennis's touchstone from very early on was John Stuart Mill, and not just the Mill of representative government, but Mill in Parliament. Real politics enters Dennis's work at every point. Bless him, he talks cases and names names. And all of this I take from Dennis to be part of the job description of a democratic theorist, of which he's the consummate of our type. I now turn things over to turn things over to Harvey Mansfield, who's going to share our first panel.
Thank you. Our speakers today are Jeremy Waldron, Francis Kamm, and Eric Nelson. All three of them have written important books, but I'll identify them, and so I'll identify them by their positions or their titles only. Jeremy Waldron is university professor at the New York University Law School and a professor of political theory at All Souls College in Oxford. And Francis Kamm is a Littauer professor of philosophy and public policy at the Harvard Kennedy School, as it now calls itself, and professor of philosophy at Harvard. And Eric Nelson, who has yet to arrive, has only one position, but that is in the Harvard Government Department. And so I think I will just turn the lectern over to Jeremy Waldron, who will speak on a paper called Dirtying One's Hands by Sharing a Polity with Others.
Thank you very much, Harvey. It's a great pleasure to be at this event honoring Dennis Thompson. And what you're going to hear is a meditation on some work that Dennis has done on the issue of dirty hands in politics, which is a major dimension of the difficulties that are associated with political ethics and with the ethics of public office. There are all sorts of ways in which one can dirty one's hands in politics. Some of them arise out of the fact that one acts in politics alongside others, particularly in a democracy. And Dennis, I think, has given more attention than anyone else to the democratic dimension of the classic problem of dirty hands. But there's a version of that problem that I want to talk about today that I think will add to, build on, and enhance the account that Dennis has given. If I may use his formulation, the classic problem of dirty hands involves the political leader who, for the sake of public purposes, violates moral principles. He may judge that he has to order acts of killing, kidnapping, or torture to avert a terrible terrorist attack. He may have to betray a whole community or the brave participants in an insurgency for the sake of lofty geopolitical values. He may stand ready to order, this again is Dennis's phrase, stand ready to order death and destruction in a nuclear exchange to deter his enemies from attacking an ally. To cite Max Weber's famous proposition, his paraphrase of Machiavelli, the ethics of political philosophy sometimes seems to require us to prefer the salvation of the city to the salvation of our own soul. Not all cases are so apocalyptic, of course. There are routine dirty hands. Nancy spoke just a moment ago about the dailiness, the quotidian character of political ethics. And there is a certain dailiness and quotidian character to dirty hands as well. Not atrociously dirty hands in the Machiavellian cases, but cases where what seem to be required are actions which are morally distasteful or morally disagreeable rather than utterly atrocious, like murder or torture. Bernard Williams, a great thinker on these issues, talked about the dirty hands required for ordinary, non-emergency kinds of political action. He says, for example, that things like lying, or at least concealment and the making of misleading statements, breaking promises, sacrifice of the interests of worthy persons to those of unworthy persons, and coercion all the way up to blackmail may all be required, or all seem to be required, of an ordinary participant in politics, certainly a participant with any power in his hands, to have any chance of successfully promoting policies that he or she judges good and just. And these dirty hands problems or dilemmas seem to be endemic rather than occasional in politics. If one is lucky, one will not have to face a choice between the security of the nation and a prohibition on torture. But no such luck can be expected in regard to these more quotidian, distasteful and disgraceful actions that I have mentioned. As Williams put it, it's a predictable and a probable hazard of ordinary public life that there will be these situations in which something morally disagreeable is clearly required. To refuse on moral grounds ever to do anything of that sort is more than likely to mean that one cannot seriously pursue even good ends in politics. So I agree with all of that, and certainly we need to understand the low grade rather than the high grade issues of dirty hands. My subtitle, or the second part of my title, is Working with Others in Politics, sharing a polity with other people. And I want to pursue this theme for a little bit in relation to the dirty hands idea. According to Hannah Arendt, we should always be mindful of participating in politics in a way that pays tribute to the fact that not one man, but men inhabit the world. Not person, but people. It's not merely that in politics one takes on responsibility for millions of other people, although one does. In a more active sense, one shares the political world with others, thousands of others, who are also committed to taking on such responsibility, and one needs to operate in an environment in which they are operating as well, especially when my moral sensibility is not the same as their moral sensibility. My reasoning is not the same as their reasoning, but I am required to respect them as they are required to respect me. And a lot of the joy of politics and a lot of the dilemmas and difficulty of politics arise out of the fact that we work in a situation where we are alongside the actions and reasons of a whole array of other people who seek to shoulder the same responsibility that we do. This point about Arendtian plurality, I think, is massively important. Now, here's my first thesis. Even though there is often a multi-person dimension to dirty hands problems, the classic problems of the Machiavellian sort, the classic problems of the leader who faces the ticking bomb or the torture, the betrayal of insurgents or the geopolitical chaos, although that involves a leader taking responsibility for a large community of other people, and although there may be specific ethical dimensions of such responsibility, the fact that one is working alongside others, that plurality point, doesn't seem to be essential to what is problematic about the classic Machiavellian cases. Machiavelli presents them, as we know, in terms of the reasoning of a particular singular political figure. Dennis Thompson has insisted that we perhaps should step away from the image of the moral agent in these difficulties as a solitary figure agonizing alone when making moral decisions and acting alone when executing them. There are usually others involved as part of a team, and so it's not just George W. Bush thinking about torture, but George W. Bush and the Vice President and the National Security Advisor and the guys in the Office of Legal Counsel and John Yoo and Jay Bybee and all these other people are thinking about torture together, and the lines of complicity may not be straightforward. That's true. And it's not just Harry Truman making a decision about the use of atomic weapons against civilian cities. It's Harry Truman and all the scientists who were involved and the generals who were giving advice. So certainly there's plurality there. But the problem of dirty hands in those cases doesn't arise out of the plurality. I mean, there may be opposition and there may have to be questions of collective decision. But the difficulty of the dirty hands cases doesn't arise out of plurality as such. Whereas in the Bernard Williams cases that I mentioned, those ordinary cases of deceit, deception, betrayal, low-grade coercion, one has to engage in those things because one needs to, I don't know, build a coalition or get people to come along with a project that they are not initially inclined to come along with, or make promises that one can't necessarily keep. The fact that one can do very little in politics without bringing on board people whose moral sensibility is not exactly the same as one's own means that one has to engage in a degree of manipulation, or that one might think oneself required to engage in a degree of manipulation. And in those cases, the plurality of politics is part of the problem. Here is a worthy politician wanting to pursue a good cause. He can't pursue a good cause without bringing other people on board, but bringing them on board and keeping them on board, or switching coalitions, or being required to build multi-person coalitions who will pursue a given project is not something that can always be done with what we would recognize as morally straightforward forms of action. So in these cases, since one can neither act alone nor assume that others with whom one must act share one's initial views of the merits of the proposal one is pursuing, one is driven to these other expedients. So in those cases, the plurality seems to play an interesting and important role. We're familiar with this, of course, all the time in politics. Political actors are often bound by principles of collective decision-making. Simplest case, I may be bound by a majority decision, even a majority that I voted against. And now I'm the political leader and I have to put the majority decision into action. I may be bound by a majority decision of my cabinet colleagues. I may be bound by a majority decision in Parliament. And then I have a responsibility to do the thing that I voted against because I judged it wrong. And in those simple cases arising directly out of plurality, I must dirty my hands in the name of the majority decision with the action that I judged to be wrong or unjust. I think these cases are interesting. As many people here know, I have long had a fascination with the virtues and the difficulties of majority decision-making. And what I want to do in the bulk of my talk this morning is to deepen this a little bit and talk about some of the difficulties that are posed by the fact that not only one shares the political world with others horizontally, as it were, people to my left and people to my right, people here and now that I have to work with, but one shares a political system with one's ancestors. One shares a political system with one's predecessors. One shares a political system with a whole matrix or array of decision makers who have gone before in the political life of the community and have left a residue of their own decision making for me to take partial responsibility for. Can I use an example from England? It's from the 1970s, and it has to do with housing policy. So in 1972, the Conservative government of Edward Heath was distressed about the way that municipal housing policy was being implemented up and down the length of the country, and they introduced the statute, piece of legislation, the Housing Finance Act, which imposed an obligation on city councilmen who were responsible for administering housing in particular cities, imposed an obligation on them to charge fair market rents rather than the very heavily subsidized or discounted rents that were being charged to poor working class council tenants. this enormously controversial at the time. This is Margaret Thatcher, 10 years before the event. Imposition of market rents. Councilmen were required to raise the rents on their houses to force the tenants to pay very considerably higher rents than they had been used to paying. There was a town in Derbyshire called Clay Cross, and Clay Cross was a Labour town. Clay Cross was largely a town composed of council municipal housing. And the Clay Cross councilmen were furiously opposed to the provisions of the Housing Finance Act, and 11 of them announced, the 11 who were responsible for housing policy in Clay Cross, announced that they would refuse to implement the changes. Defiance of the law. You could say even at that stage they refused to dirty their hands in administering a piece of conservative legislation. Local government background law requires that if somebody behaves like that to defy financial regulations, they must be personally surcharged. They are held personally liable for the amount of money that the council loses as a result of their unlawful actions. So very quickly, financial penalties are building up in the hands of these councilmen. And if there are several thousand housing units and the rents are not being raised by £5 or £10 a week, then very quickly, even divided by 11, these are very substantial penalties, building up through the hundreds of pounds into the thousands of pounds, and triggering another background provision, which is if you have been surcharged more than £500, you will be disqualified from the office you hold, and disqualified from ever holding office in this municipality again. So a lot of background law was triggered and went into effect. Huge controversy in the country. The Labour Party, in opposition, had a convention, and from the floor the motion was moved that they would not only repeal the Housing Finance Act as soon as they were elected to government, but they said they would indemnify the councilmen who had been surcharged and disqualified from this. And there was a lot of unease about that. Again, there was a dirty hands problem. If they came to office and didn't indemnify the councillors, then they would be required effectively to administer these penalties, which they thought were disgraceful and unjust under previous legislation. So they made a commitment to indemnify the councilmen. Labour was elected in 1974 and came into office, and people like Sam Silkin and Anthony Crosland, honourable men committed to the ideas of the rule of law, had to swallow hard and implement this policy of indemnification, to indemnify the councilmen, even though they thought that that was a bad thing to do, because after all, the people had broken the law as it then was, and even though the law was going to be repealed, it wasn't necessarily a good idea to try to pretend that the law had never existed. So you have at least three sets of possible dirty hands in this situation. One is that the Clay Cross 11 refused to dirty their hands with the Housing Finance Act's administration. Secondly, the Labour Party refused to dirty its hands with the administration of the penalties, and the continuation of the penalties and the continuation of the disqualification. And thirdly, Crosland and Silkin were very, very upset about having to dirty their hands with an indemnification policy that they thought was a violation of the rule of law. So a complex, nested array of dirty hands possibilities, arising again from this more general principle that one shares the political world with others. As the Clay Cross councilmen share the United Kingdom with other people who have voted for a Conservative government. Anthony Crosland shares the Labour Party with other people who are more in favour of indemnification than he is. And the government shares the political world with lawmakers who have gone before them. Those nested, difficult issues of dirty hands seem to me to be worthy of some meditation. Now, there's a written version of this paper and there's a spoken version of this paper, and in the spoken version, I'm going to concentrate particularly on the issue of dirty hands that is posed, that would have been posed counterfactually if the Labour Party had accepted that indemnification was inappropriate. If it had accepted the rule of law argument that penalties must not be retroactively reversed, then it would have had to dirty its hands with laws passed by its predecessors. And I do think this is an extremely interesting aspect of the approach to dirty hands, is this business of thinking about the responsibility one has, the responsibility one takes in public office, not just for one's own actions and one's own decisions, but for the actions and decisions of others who have gone before. So, the Labour people would have felt that they were soiled by having to continue to administer and uphold penalties imposed under a law to which they were implacably opposed. On the other hand, until it was repealed, and it eventually was, the Housing Finance Act of 1972 stood in 1975 as a part of the law of the land. Its status as such was not affected by the election of the Labour Party in 1974 or by the ouster of the Conservative government whose parliamentary majority had enacted the law. It's a general point, and we know it. It's a way we work in modern democracies. All sorts of laws outlive the governments whose majorities enact them. Some of them live on for a few months. Some of them live on for a few decades. Some of them live on for centuries. We do not work with any sort of year zero principle, which would hold that when a new government comes to power, the slate is wiped clean and all the laws enacted by its predecessors are deemed now to be invalid. The legal measures that have been enacted by one's predecessors, the legal arrangements that a given government inherits, live on unless something specific and focused is done to repeal them, one by one, law by law. So when Labour took power in Britain in 1974, it inherited an array of laws enacted by its Conservative predecessors and an array of laws enacted by the Conservatives' Labour predecessors, and some laws enacted by the Conservative administration before that, and so on, all the way back to statutes of medieval monarchs that nobody ever got around to repealing. The statute book is replete with legislation that has survived 4 or 5 parliaments, or 20 or 30 parliaments, or in Great Britain 200 or 300 parliaments. And it's not just legislation. The principle of stare decisis ensures that judicial decisions outlive the judges. Long after the judges who have made a particular decision have gone under the ground, the decisions that they make live on in the books of precedents and continue to influence. And those who now inhabit the world must take responsibility for administering those precedents as well. Of course, precedents can be overturned, but again, they have to be overturned one by one, not wholesale in a year zero sort of way. Our law is a kind of archaeological midden. Yeah? It's a rotting, not a rotting mass, but it's a decomposing mass of strata and layers of law, layers of decision, layers of regulation, many of which have long outlived the controversies that once surrounded them. And the principle of the rule of law, is a principle that commands respect for all that. It commands respect not just for the laws that you enact, but commands respect for the law of the land as this messy, layered, decomposing body. And it requires, as a matter of understanding the rule of law, it's going to require politicians of one stripe to have to dirty their hands with the administration of laws passed by politicians of a different stripe. And that, of course, is exactly what's going on in this Clay-Cross thing. It's relatively proximate. We're not digging down centuries. But a law passed 2 years ago with which there is profound disagreement now has to be administered by the government that comes to power, at least until it's repealed. And even if it's repealed, there is the residue of its administration when it was law. Either these guys are going to be disqualified or not. They're disqualified under general background principles of local government law, again passed in the 1920s and 30s, but which when matched with the Housing Finance Act of 1972 mean that people who take a particular stance on housing rents and so on will have to bear the surcharge penalties and will have to bear the disqualification. And again, our principle of the rule of law commands us, even if we are going to repeal a given statute, that we are not to airbrush out of the picture all of the instances of its previous enactment. Now, I don't think this is true in an absolutely unqualified way. Maybe there are some regimes so wicked that we do want to have something, if not a year zero mentality, then back to the status quo ante. After the fall of the Nazi government in Germany, if it was a government, in Germany in 1945, we, at a stroke, undo all Nazi legislation and probably empty the jails as well as emptying the camps. And similarly, with the abolition of with the emancipation of the slaves and the enactment of the anti-slavery amendments and statutes, we effectively do away with a whole layer of law that had been in place for almost a century. But these are apocalyptic cases. These are cases of massive systemic injustice. And there we do adopt a wholesale rather than a retail approach. And we do try to do away with not just the laws themselves, but with the residue of their application. Yeah? Then there are in-between cases, like apartheid South Africa, where we do away with a whole range of laws, but not necessarily with the property rights that grew up in and around them. But I'm interested again in the dailiness of ordinary politics, not just these apocalyptic cases, and the dailiness of ordinary injustice. Many of us think that the laws we are governed by, or some of the laws that we are governed by, are unjust. This is bound to be the case, because the laws take positions on issues of justice, and we disagree about issues of justice. So we can't all be right that they're unjust, but we really can't all be wrong either. Yeah? And it is the case from our point of view that given this layering, we are going to confront and having to administer laws that will be unjust, and we are going to have to administer a body of law, a corpus juris, comprising legislation and precedents that is layered, marbled, striated, imbricated. I tried to come up with some more synonyms, but that was about as far as I got. But the whole thing is shot through with what a particular person will regard as injustice. And it seems to me part of the duties surrounding political office in a rule of law system where there has been turn-taking in government based on democratic principles, that one has to take responsibility for the whole midden, not just for the particular parts of it that one relies on. As some of you know, I'm a great fan of the work of Ronald Dworkin in jurisprudence. And I believe that even though a judge deciding a particular case is often just dealing with the interpretation of one particular section or one particular clause or statute, nevertheless, as soon as legal argument begins, and as soon as people start disagreeing about interpretation, there are going to be questions about the coherence of a particular interpretation with the whole body of the law. And again, that means that in the name of legal integrity, one has to keep faith with the whole damn thing. And one has to prefer one interpretation to another interpretation on the ground that it is more consistent with the whole body of law for which one has to take full and total responsibility. So legal integrity is going to require one pro tanto to keep faith with past legal decisions or with decisions that have been made to the left of you and to the right of you that you yourself feel morally uneasy about. And this will be characteristic of the judge's role. We've mostly been talking so far about the politician's role. But for those who have this particular responsibility for administering the law, they have to take responsibility both in detail and in general for many provisions, many of which they will regard as unjust if they ruled the world and were able to wipe the slate clean. This, as I have stressed several times, is not just occasional or a matter of bad luck for the political actor, for the judge. This is business as usual in rule of law politics. This is par for the course, given adherence to principles of legality. And it generates, I think, something like a dirty hands problem or a dirty hands idea for those who are saddled with this responsibility. Now then, in the classic cases of dirty hands, the torture ticking bomb cases, the Machiavellian cases, the democratic cases that Dennis discussed, it is, I believe, possible to give an analysis of what is going on an analysis of why one is required to act in a certain way, and an analysis of why it's important to keep hold of a sense of the wrongness of what one is doing, even when one is required to do it, it's possible to give that complex analysis in terms of reasons and moral considerations that apply to the particular actor. The prince or the political leader knows that there are very strong considerations that apply to him in terms of the responsibility that he has taken on for the well-being of a city or a country that seem to require him to perform an action of a certain type. He understands that the action of that type is normally regarded as wrong, and he understands why it's normally regarded as wrong, but he can do moral analysis of his own position in relation to the terrible circumstances that he faces to understand why nevertheless he is morally required to do what is ordinarily regarded as morally wrong. And not only that, he may be able to engage in moral analysis at the level of reasons that apply to an individual, to be able to characterize why it's important to hang on to the sense of the moral wrongness of the action. He might say, with Bernard Williams, only somebody who is reluctant and is squeamish about doing the morally wrong thing when it is necessary, only such a person has much chance of not doing it when it's not necessary. Yeah? We need to maintain the inhibition even in the face of the situations when it's also morally required to override it. So we can give an analysis, a complex analysis, I think, of the problematic and difficult position of a ruler faced with these hard choices in terms of individual reasons applying to an individual person. And it's possible that we can do that for many of the majoritarian cases as well. I have a view about the injustice of the statute. That's a matter of the reasons that I might have for voting against it. But I also adhere to the moral principle of majority decision because I understand that in terms of the points about fairness and political equality that Jenny spoke about yesterday. And I see those as moral reasons that bear on me as well. So I can bring these two sets of moral reasons together, and we all understand that moral reasons do come together in complex, sometimes oppositional relation to one another in difficult dilemmas. So we can, if we are determined enough, work our way through these decisions about dirty hands using individualized morality that takes account of special circumstances, takes account of what other people have done, takes account of norms of respect for what other people have done. But here's my speculation. I'm not sure that it makes sense to give that individualized moral analysis of all these cases. And I'm not sure that it works for the cases about legality and the midden of the law that I have been speaking about. I'm much less sure about using the essentially individualist account of ethics, the individualist account of the ruler's ethics, to characterize what is going on in the case I mentioned about the Labour Party having to uphold penalties imposed under legislation enacted by its predecessors. I'm unsure, and I want some suggestions from my colleagues on the panel and from my colleagues in the room about whether it might be important to switch to a different approach. When one is a law officer, like a Solicitor General or an Attorney General, when one is an officer of the law, like a judge, it seems to me one is not simply adding a whole new set of reasons for action to the reasons for action that one already has. One is stepping into a different role, and I think Dennis accepts this and has written a lot about it, the fact that political ethics is not just an ethics of arrays of different kinds of reasons, but it's something more robust, like stepping into a different role, in which one is speaking and thinking and acting not in one's own name at all. One is speaking, Montesquieu used the phrase, judges speak as mouthpieces for the law. They personate the law, to use a Hobbesian idea. And so that it's probably misleading to say that, well, all that's going on is one and the same individual has added a new set of moral considerations to be ranked alongside and balanced alongside the other set of moral considerations that would have informed his first order judgments on this matter already. I want to say that the law officer steps away from the views that he has as an individual and is required to adopt the perspective of society as a whole concerning the law as a whole. And this displacement into a separate role in which one not only puts on a different hat, but personates a different kind of entity, is different from a calculation that admits the reasons that he has or had for opposing the law and balances those in a simple weighing fashion against his separate individual duty to uphold the law as it is. I don't mean that no weighing or balancing of reasons is required in this different role. A law officer or a judge may have to weigh and balance considerations of certainty in the law, considerations of whether it's appropriate to overturn a precedent, considerations about how to interpret a particular provision. So there's still weighing and balancing being done, but the weighing and balancing is now being done by this entity that looks like the individual who is doing the moral calculation on this other picture, but is in fact it's being done by an individual personating the community as a whole, and everything that the individual says as a judge or as an attorney general or Tony Crosland as a minister responsible for the Housing Act, everything that he says and does is being said and done in the name of an entity that is larger than himself. Not just that he has to take into account the views of other people who compose that entity, but he is personating that entity and acting separately. Certainly, it seems to me that that is true of the judge, and it's a mistake to think, well, the judge is just an ordinary person with ordinary moral reasons that apply to him, plus extra moral reasons that apply to him by virtue of the fact that he's remunerated and warranted as a judge. I think that the burden of being a judge is that you have to step out of the role of individual moral agent and take on the role of speaking for the law as a whole. If this hunch is correct, then the problem of dirty hands in cases like this is best unraveled in terms of dissonance between roles rather than in terms of the complexity of moral reason. I say it's a hunch, and I didn't even want to put it forward as a thesis because I know there are going to be limits to it. That one has to keep faith with the role, put on the wing, act in the name of the law. It will itself seem like, at certain moments, a moral duty on the individual. And the individual who is a law officer, an officer of the law in a radically unjust system, must eventually make an individual decision about whether he wants to continue to step into role or whether he wants to walk away from it. Right? So there's going to be a dimension of individual decision there, and that will have to be understood in terms of, I think, reasons that are incumbent on the individual. And we think, for example, that people who were impaneled as judges in Nazi Germany, and perhaps in the cases that Robert Cover talks about in Justice Accused in the antebellum United States, and sometimes this is said about Goldstone and others in South Africa, there is a case that can be made that these individuals, as conscientious individuals, should have refused to step into role as judges in these cases. But for ordinary cases, the quotidian version of this dirty hand arrangement, I'm inclined to think that the better analysis is to say that sure, one makes ultimately, as a background matter, a moral decision as an individual to continue and to assume and then to continue in the role that one has taken on. But once one steps into role, it is, I think, misleading to present it as a purely individual ethical decision. Sometimes the ethics of public office require us to act as though we were not making ethical decisions on our own account. Still, I'm nervous about this hypothesis, and my nervousness is mitigated by the thought also that it may not be a huge difference, it may be just a minor difference of moral vocabulary. We know that, of course, the dissonance that characterizes the dirty hands is experienced by a flesh and blood individual, right? The problem that he has is that he is concerned about what his legal role requires him to do not just requires the law to do. It's this juxtaposition that makes him feel that he is dirtying his hands by his own standards when he acts as a judge. That's inescapable. There's no getting away from that consciousness. But I think it is really a case of double consciousness here, that the law officer or the judge has two juxtaposed lines of moral reasoning. And I don't think the best way to understand that is in terms of weighing and balancing reasons of different sorts that apply to one and the same individual. That's the inconclusive note on which I wish to end, but it's really a quest for guidance as to how to think through these cases. Thank you very much indeed.
Francis Kamm to respond.
You're going to hear some things about the parts of the paper that were not read. So I'm hoping this is adequate. Jeremy Waldron believes that one way of conceiving of the problem of dirty hands is as a question of an individual choosing between a lesser and a greater evil. His account of this is sometimes subjectivized in that he says that at least from the perspective of the agent, it seems that one course of conduct is a greater evil and the other a lesser evil. And it seems to the agent he will dirty his hands if he does one of the acts. So, for example, one of the cases he gives is a ruler may see leaving his citizens to be massacred by an enemy as a greater evil and is harming one innocent person to stop this as a lesser evil and see himself as dirtying his hands in doing the lesser evil. To begin with, I just want to ask the very simple question, can the ruler actually dirty his hands if he's mistaken that the option he chooses is in any way wrong? So, presumably not. I just want to get that straight to begin with. If a ruler believed that eating broccoli was wrong and would dirty his hands in eating it to stop a massacre, from objective view, he's just wrong. He hasn't dirtied his hands, okay? And I'm going to assume henceforth that we're dealing with matters of objective lesser wrong and greater evil and so forth. Waldron thinks that even if it were a more serious wrong for the ruler to leave his citizens to their fate, that does not render the harming of the innocent no evil at all. This is a case where there is a grave violation of justice, but he also uses the term evil to refer to less serious moral transgressions such as lies or coercion, the Williams type things that he sometimes calls disagreeable. My sense is that he wants to claim that in harming the one person, for example, the ruler is still doing something that was, what he says, prima facie wrong. That is to say, ordinarily wrong, given that there's no justification for doing it. And at the very least, I quote, something of the initial judgment that it is wrong survives the judgment, ultimate judgment, that it is morally right to do this, to do the harm to the person, the innocent person. He says, what survives is its moral disagreeableness. Of course, it retains negative properties, as harming this person and so forth, the innocent person. And we should try to avoid these things in the future, right? Hence, the ruler has dirty hands in doing such an act, I think, on Waldron's account, even if the act is not ultimately a wrong act. It was prima facie wrong, it continues to have these disagreeable properties. Therefore, Waldron seems to reject the position that some take that says that the problem of dirty hands depends on the view that no matter which act you do, including the lesser evil, you're going to be doing an ultimately wrong act. Okay, and I actually agree with him. I don't think that position is correct, the one I'm contrasting him with. Now, presumably, if the ruler were to do the hypothetical greater evil and leave his people, I'm saying hypothetically, suppose we agree, leave his people to die to avoid doing the lesser evil of harming the innocent, he would also dirty his hands. And more than that, he would have dirtied his hands by doing the overall wrong act. I'm just saying suppose. Now, suppose our condemnation of him in this case would, for some reason, not include the charge of dirty hands. Maybe in virtue of our recognition that the harm he would have had to do in order to do the overall right thing, was just harming this innocent person, right? If that were so, then we would be committed to saying, if it were so, in other words, that we wouldn't say that in doing the overall wrong thing, he had dirtied his hands. We wouldn't say that. We would be committed to be saying that in doing the overall wrong act, one does not always dirty one's hands. In particular, if one would dirty them in doing the overall right act. Now, this would be a puzzle, I think, and I'm going to return to it below in what I say. Now, I believe there is a somewhat different way than Waldron's to conceive of the problem of dirty hands as faced by an individual on his own, standard case. To see this, first consider the following sort of case in which one chooses the lesser evil. Suppose that Joe wants to kill some people to express his anger at the world. He has to decide whether to set a bond that will kill 5 innocents or alternatively shoot to kill one other innocent person. He decides that though he will kill someone, he should really do the least amount of harm. That's why I brought a very small gun with me. I have it in my bag. So he chooses to do the lesser evil, and he only kills one person. Now, in this case, though he chooses to do the lesser evil, there was no good reason for him to do any evil. It would not have been a greater evil for him not to kill anyone. In this case, it seems easy to say that though he does the lesser evil, he does the ultimately wrong act, or an ultimately wrong act. An ultimately wrong act. By contrast, in the case of the ruler that Waldron gave us, it is assumed that either leaving his citizens to be killed or killing one other innocent as the way to stop the massacre are his only or least problematic, morally problematic options. That's it, okay? According to the alternative construal of dirty hands that I'm just now considering about applying to this case, if harming the one person is the overall right course, then harming the one innocent person is not a wrong act, but it is an act that involves wronging the one person. So this is the addition, I think, to Waldron's account. It wrongs him because while it may be justifiably overriding his right not to be harmed in order to save all those other people, it does not harm the one innocent because he in particular has done something or is in a threatening position of some sort that would lead to him being liable for being harmed or to being harmed. If he were liable to being harmed, in virtue of his actions or his position, threatening position, he would not be wronged even in being harmed. On this alternative view, as on Waldron's, I think Waldron's, one can dirty one's hands in the course of doing the overall right act and without doing any wrong act, but in wronging someone. Okay? Now, wronging someone may result in regret, apologies called for, perhaps compensation if it's possible, but it doesn't involve the violation of someone's rights. It's this permissible overriding. Okay? And I'm just wondering whether Waldron would accept such a revised view. Now, Waldron not only has a particular understanding of the problem of dirty hands, he has views about the type of situations in which it can arise. And you could imagine a 2-by-2 grid. I'm very bad I can't even write on whiteboards anymore. I'm becoming increasingly less technical. So just imagine, this Machiavellian contrast with the Arendtian. I call it the non-collective, the individualist versus the collective. And imagine that, under these two rubrics, on the left side of the little grid, you have either a grave injustice or a non-grave, lie, coercion of some sort, okay? Now, Waldron says that the ruler case I've described is best conceived as falling under non-collective grave. The ruler and the individuals who may work with him form one group, and they face doing what would ordinarily be a grave wrong because of events beyond their control, let's say caused by enemies of the country. The politician had to commit what would ordinarily be a non-grave wrong, for example, lying, because, let's say, of natural events beyond his control. This would be a non-collective, non-grave case. Waldron distinguishes such cases from what happens to various Labor Party agents in the Clay Cross case, who may have to do what would ordinarily be a wrong act because of what others who were entitled to act have already done from the sake of their moral views, right, which differ from those of the labor rights, okay? So one might say that, I'm omitting certain things that one might say, but I'll say one of them that one might say. One might say that Waldron is concerned with hands that become dirty because they are tied in a certain way, in particular by acts of lawmaking, okay? So this becomes increasingly kinky. Dirty, tied hands, right? What is that? Wonderful. Yeah, right. Okay, so, I have several concerns about the way he describes these contrasts, but I hope I have time for at least one. One concern I have is that what the conservatives did might not arise from their having different moral views than the laborites. So hypothetically, for example, they might have passed the housing bill that Waldron described, though they too thought eviction would ordinarily be wrong. Right, and punishing people who didn't evict would be wrong, in order to avoid a greater evil that faced them, right? So this greater evil might now have passed, and the laborites might have done the exact same thing had they been in the situation the conservatives were in, facing that greater evil. Because it's just another case of dirty hands, right? But of course, Labor did not pass the bill, and now they have the problem of deciding whether to enforce it. So perhaps even parties who share moral outlooks could create the sorts of problems for themselves that arose for different laborite agents in the Clay Cross case. The question also arises of whether the laborites would face similar problems if they in fact had morally faced that greater evil and had to pass this law as a lesser evil. They had passed the law, and it couldn't be revoked, but they had to now enforce it. So I'm not sure that, different views, different agents is necessary for this problem to arise. So that's another question. But given that the problem of dirty hands could arise for this particular person, Anthony Crossland, or the Clay Cross councilman who refused to evict tenants, in the collective manner, different individuals having different moral views in the way Jeremy describes, the question then is whether we should analyze the decision-making of an individual such as Crossland in the same way as we did in the Ruler case, an individual deciding between weighing greater and lesser evils, right? And in Crossland's case, at least, in the paper, Waldron thinks that the way to represent the problem of moral hands there is rather that the individual is in a role. This repeats some of what he says about the counterfactual of the laborites actually enforcing the role. In the paper, he talks more about Crossland being in that role, okay? So he thinks an appropriate way of looking at Crossland might be that the individual is in a role in which he serves some entity outside of himself and must decide what to do on the basis of considerations that apply to that entity or arise from its perspective. The sense that his hands become dirty is best represented not by his doing what would ordinarily be wrong when it is indeed what faithfully serving in this agent role requires, but by the juxtaposition of his action in that role and what he would do if he were outside the role. That's what he says, quote, page 25. Now, I agree in part with Waldron on the effect that being in this sort of an agent role can sometimes have. In an article like mine called Responsibility and Collaboration, I argued that if it is permissible to take on a role such as being a lawyer, in which one is an agent for someone else, such as a landowner, then if one evicts tenants as the landowner's agent, even if the landowner's evicting is morally wrong, though he has a right to do it, one does not dirty one's hands as the agent. Any form of dirty hands goes to the landowner, even though he was in bed when the lawyer did the eviction, right? However, the lawyer may acquire dirty hands by taking on the agent role, if that is the overall wrong thing to do, given that he knows what he's have to do, and also by then carrying out any wrong evictions. Okay, so I think this is our points of agreement. What I find puzzling in Waldron's discussion of the agent role is the claim that the agent's sense that he has dirty hands arises from his juxtaposing what he would do in the role with what he would do if he were not in the role. For we know, on the basis of an individualistic analysis of Crossland that Waldron himself gives, that if Crossland were to model his thinking not as an agent, but simply as an individual, his sense that he has dirtied his hands in the role of being an agent could not come from the fact that if he were not in the role, he would not be doing the same act. For under the individualist, non-agent analysis of Crossland that Waldron gives, he would also have decided to carry out the Labour Party majority decision. Now, of course, this act of carrying out the decision is not the one of upholding the law that the Conservatives passed, that Crossland would have done had his hands not been tied by the Labour majority, who overrode him when he argued that that's what the decision of the Labour Party should have been, to enforce the law. So my sense, therefore, is that Waldron is giving pride of place in his account of dirtying one's hands to someone's not doing such an initially preferred course of conduct, the course of conduct he would have preferred prior to any decision that then he thinks supersedes his own. Now, I would call this Waldron's asymmetrical view of dirty hands. If it's not his, then just call it asymmetrical view of dirty hands. By contrast to what I would call a symmetrical view of dirty hands. I first noticed this asymmetrical view in Waldron. I thought it was creeping through when Waldron described, as he did here, the Clay Cross Council members in not enforcing the housing law as, quote, having decided not to get their hands dirty, page 14. But, end quote. But if not enforcing the law is also ordinarily a moral wrong, and even they recognize this, it should be true that they also dirtied their hands and thought they did in not enforcing the law. Waldron says that Crossland thought he dirtied his hands in not enforcing the law. Not enforcing. But on the symmetrical view, he would also have dirtied his hands if he had not followed the rule of the majority of the Labour Party, because he had a duty as a Labourite to follow the majority rule. Yet the asymmetrical view gives pride of place in a description of dirtying one's hands to someone's doing or not doing what he initially tried to convince others was the right course of action. For example, in the case of the councilman, not evicting, or in Crossland's case, follow the rule of law, all right? And this is the sort of thing that he tried to initially convince others was right, before others' decision went against him, right? It seems that on the asymmetrical view, dirtying one's hands retains a subjective element. One will dirty one's hands only in going against one's initial position on a particular issue, not in going against one's ultimate position on whether someone else's view on that particular issue should determine one's conduct. One has this superordinate view, as Crossland did, that the majority's decision should govern and supersede his own view about the particulars of the issue. The asymmetrical view, and Waldron's, if it is his, and there are so many cases where the language suggests this view creeping through, can result in the puzzle that I described earlier on in my paper. Namely, that one could fail to get dirty hands in not doing what one thinks is the overall right act. And so one could fail to get dirty hands, right, in actually doing the greater evil. And this is a very peculiar result.
Thank you. Thank you, Francis.
Did I make it for 15 minutes?
No, that was very good. It worked whatever minutes ago.
Eric Nelson also to respond.
Oh, I'm sorry, there's only one mic.
There's only one. Can we go?
It should be called Bill Clinton, there's only one.
Thank you. And first of all, can I just apologize to Jeremy for coming in late. I brilliantly went to the law school and was looking around for our conference and thought I was having a sort of waking version of that nightmare where it's your last college final exam and it isn't there. But I found it. So anyway, thank you very much. It's a pleasure to be invited to participate in this program to honor a very dear friend and colleague Dennis Thompson, and to have the opportunity to respond to Jeremy's paper. When I saw him yesterday and I said that I had to duck out of the dinner to go and look at the paper and figure out what to say, he assured me that adulation would be entirely sufficient. And so, so let me begin with adulation. I enjoyed it a great deal and learned a great deal from it. I'm just really going to raise two general questions about the structure of the argument, and one of them will touch slightly on one of the issues that Francis raised, but I think they're sufficiently different. So the first is about this issue of plurality, the sort of plural character of the agents involved in the kinds of cases that Jeremy's interested in. So he's distinguishing in the first instance between, as he says, Machiavelli-type cases, which involve the prince, as he says, as an individual agent in the singularity of his particular care for his city, whereas the other kinds of cases, including the Williams-type cases and the Claycross-type cases, involve a context in which, as Jeremy says, an agent shares the world with others and has to act politically with them. So my first question, I guess, is just a smaller one, and it's about whether plurality understood that way excludes, actually, or is not present in the Machiavelli-type cases. Because if the claim is, as Jeremy puts it, that given this fact of plurality, that is that one inhabits a world with others and has to act politically with them, there are limits to what one can do without the acquiescence, cooperation, or enthusiasm of others, then it's certainly true that in the Machiavelli-type cases, certainly in the Prince, the others involved aren't co-rulers, strictly. But, of course, there are multiple other kinds of agents, and it seems to be exactly the presence of those agents that generates the problem of dirty hands for Machiavelli. As he puts it, the fact that one needs the cooperation of others in order to do what one wants is what kind of changes the calculus and requires him to give the advice that he gives in Chapter 15 of The Prince, where he says, how men live is so different from how they should live that a ruler who does not do what is generally done but persists in doing what ought to be done will undermine the state. So the point is that if the subjects whose acquiescence, cooperation, enthusiasm, participation one needs in order to do particular kinds of actions were reasonable and virtuous, easily convinced, that they should offer the requisite sort of cooperation and support to the state, there would be no need for the prince to dirty his hands. So I was interested in hearing a bit more about the difference between sort of what work the fact that the different agents are co-rulers as opposed to simply others whose cooperation one needs in order to do what one wants to do is doing in that part of the argument. But the more important kind of plurality that Jeremy's interested in, which applies to the Claycross cases, is a kind of plurality involved in the profile of the agents in the case, where, as he puts it, these cases involve situations of other persons having already acted in the polity that one shares with them. So the question that I really want to pose is whether in that formulation it's really the other person's bit, that is the plurality of the agents involved, or the heterogeneity of the agents involved, as opposed to the already acted bit that's really generating the interesting dilemma that Jeremy talks about so fascinatingly. So to put it differently, the issue, it seems to me, that Jeremy is really talking about, that is the rule of law, the imperative to respect the legacy of past actions as part of the law of the land, as he puts it, even if one regards those actions as unjust, seems to me only contingently related to plurality in his sense, that is, to the fact that other people were the source of those actions. So just to make the point, suppose, as I enjoy doing, that the two English revolutions of the 17th century had turned out differently, and that the Housing Finance Act that Jeremy is interested in had been promulgated by a hereditary monarch in 1972, who could do that kind of thing, and not by a political party in the House of Commons. So suppose that the same monarch then concluded in 1975 that she'd been in terrible error in promulgating that law, that actually the law was deeply unjust. So in this case, the issue isn't to do with the plurality of the agents in question, it's the same person. If anything, the question is one about the relation between the monarch circa 1975 and her former self in 1972. But it seems that she faces the same core dilemma that Jeremy is interested in, notwithstanding this fact. That is, she believes that the promulgated law is unjust, even though it came from her. That seems unimportant, but that there are nonetheless reasons of principle, settled expectations, the imperative to avoid what Jeremy calls the year zero style of reasoning, that tell her that while it might be a good idea to repeal the law, she shouldn't retroactively refuse to enforce it, let alone penalize people for abiding by it and enforcing it. So that would be my first question, is just about whether plurality, the sort of the difference in the agents, is really what's making the case that he's interested in as interesting as it is. The other question that I have is about the claim that comes in at the end about cases of playing different roles in which one is speaking for others, and Jeremy's hunch, as he puts it, that these kinds of cases will be not easily assimilable to the model of an individual who's simply weighing moral principles and trying to determine a correct course of action, sort of in propria persona, but this is a different kind of case. So I think I'm completely sold that this is an interesting and certainly different kind of case. The question is whether the cases are different in kind from the others in the relevant sense. That is, whether they're not captured adequately or plausibly by the model of the single agent deliberating and weighing principles, or as Jeremy puts it, that we would do some kind of violence to the case if we were to try to explicate the dilemma in terms of competing moral considerations that bear on individual choices. So in wondering about whether that's true, you might just take a first stab at it and think that actually this notion of inhabiting or playing a role while also being just a sort of a normal, natural person, as Hobbes would put it in the language that Jeremy's interested in, would be readily assimilable to this kind of principle-weighing account of dirty hands. If I've undertaken or promised to play a role in which my actions are to be constrained by the wishes of people who aren't me, that is, I'll agree as your proxy to make whatever chess move you instruct me to make, even if I think it's dumb, or as in Francis's case, I'll agree to enforce laws that my superiors make, whoever they are, even if I wouldn't have made those laws. But when I judge those laws to be not merely unfortunate or undesirable, but actively unjust, I have a conflict between the principle of justice and the principle that tells me that I should perform my promised role. And depending on one's view of this situation, we might want to classify it as a case of dirty hands. So the difference in kind argument, the idea that that's not the right way of thinking about what's going on here, seems to depend, in contrast, on the view that Jeremy alluded to, that is the view that he rightly attributes to Hobbes, that when I act in a given role on behalf of others, it is not me acting at all, as Jeremy put it. And he cites chapter 16 of Leviathan. I'm going to follow this up, not just because I'm a more historical type and I'm frantically swimming for dry land, but because I actually think that focusing on this might highlight a particular dilemma. So that is, remember what Hobbes's view is. It shows up most famously in this discussion in the 42nd chapter of Leviathan, where he's talking about the question of whether you should commit idolatry or sacrilege if you are instructed to do so by the sovereign. And his answer to that question is Yes, of course you should. So why? He gives you the case of this figure Naaman in the Bible, who has a conversion experience, now believes in the true God, and wants to shun and avoid idolatry. But his master is an idolater, so when he goes to the temple with his master, he says to God, listen, I would never do idolatry myself, but when I go with my master and he requires me or pushes me or tells me that I should do it, I shall, and please pardon me. And God says, okay, I'll pardon you. And so the question for Hobbes is, how is that consistent with Matthew, where Jesus says, whoever denieth me before men, I will deny him before my Father which is in heaven, because, as Hobbes says, when you bow down to the idol, of course you're denying the true God just as much as if you were to do so with your own lips. And Hobbes' answer to this is as follows: this we may say, that whatsoever a subject, as Naaman was, is compelled to do in obedience to his sovereign, and doth it not in order to his own mind, but in order to the laws of his country, that action is not his, but his sovereign's. So here's how I see the dilemma that might be involved here by flirting with this view. So on the one hand, you might say, well, we should resist this view, that it's just not the action of the agent at all. And in fact, of course, Hobbes himself resists this view. The whole point of the preceding 41 chapters was to explain to us that the sovereign's actions are all our actions anyway, so that even if Naaman's action is the sovereign's is actually his, and so he remains the author of the action. So the whole point of personation for Hobbes is that I recognize myself in the authorized institutions of the state, so they're me after all, in any event. But even if that weren't true, even if I couldn't recognize myself as the author of the relevant actions, it seems that I would still be confronted with a version of the familiar kind of case as long as I believed that when I'm ordered to act as an agent of others to commit an unjust act on their behalf, in some sense, I myself am still acting. So in that case, the conflict still emerges because the demands of justice, as I understand them, are in conflict with my obligation to carry out a role that I've undertaken to perform. So this dissonance between roles, as Jeremy calls it on that account, seems to look a lot like the individual case of weighing these different moral requirements that arise out of the fact that I have taken on a particular kind of role. But if we go the other way, on the other sort of horn of the dilemma, and we say, no, let's accept Hobbes' view, as stated in chapter 42 of Leviathan, that when I'm acting as an agent of others, I myself am just not acting at all. It isn't me, it's him. In that case, then, it would seem we're no longer in the realm of dirty hands at all, because I would in no way seem to violate the demands of justice by committing the unjust act, because I wouldn't be acting at all. So my question is whether the cost of making the Claycross kind of case distinct in the way that Jeremy wants is to risk making it something other than a case of dirty hands. So.
Being the moderator, I have no question, but a moderate question for which I'll try to suppress the Joe Biden side of my character. Aren't you saying, or are you saying simply that the notion of moral autonomy is incompatible with human or democratic sociability, and that a person who tries to operate under the notion of moral autonomy will become headstrong, self-righteous, yet squeamish? And what is the problem of dirty hands? I don't find it in Aristotle, which already means there's something wrong with it. Isn't it the human condition to have dirty hands? Don't you wash your hands only in order to dirty them with something else? I suppose the modern solution for dirty hands is rubber gloves. And maybe that's what you meant by office or role. It gives you a certain distance from yourself. I loved your phrase, on your own account, on your own moral account. if there is such a thing. And then there's the question of whether dirty doesn't really mean, and here's where squeamishness comes in, doesn't really mean bloody. And I heard you say, I think, that a ruler is lucky if he goes through his term of office without having to torture someone. Did you? Mm-hmm. That I finished.
Oh.
Yeah.
Shall I respond
yes,
to some of these comments just very briefly? I mean, I do think that there is a lot to what Harvey said in his first question, that by preoccupying ourselves with problems of political ethics, the ethics of office holding, we must beware, I think, of parading the moral sensibility of this particular autonomous individual as what ultimately is at stake in the issue. I know that many people want to say, well, of course that should be subordinated to the moral significance of the considerations that one is weighing, but also I want to say one ought sometimes to step away from a sense that ultimately it's one's own weighing. What really matters with political ethics is what Waldron does for me, and that we have to take responsibility for our actions in that sense. I do believe that there is, if not rubber gloves, there is this dissonance between the kind of moral reasoning that we do when we weigh considerations back and forth with one another, and the kind of moral reasoning that is done, and sometimes done in our own mouths, when we act in the name of others, especially when we're acting not just as an agent of one principle, and everybody scurried back to that particular image, but when we act in the name of a whole society, millions of people present and past. That does seem to me to be a different kind of picture. And I am worried about an analysis that would simply say, look, just as sometimes in moral life I have to weigh the principle of promise keeping against the principle of giving aid to a stranger when a stranger needs help when I'm on my way to go and meet somebody for lunch, just as I sometimes just have to weigh one principle against another, one set of reasons against another set of reasons. So similarly, when I hold office in a large and historic republic, I sometimes have to weigh the principle that says follow justice against the principle that says follow the majority or follow the instructions that pertain to one's particular office. Quite apart from anything else, it's going to be very, very difficult to see how you could hold on to some sense of justice as the first virtue of social institutions unless you are willing to distinguish the levels of reasoning that are taking place rather than simply seeing them as coordinate arrays of reasons operating on the same level. I much appreciated the comments of Francis and Eric. I greatly appreciated the power and the challenge in Francis's comments. And if I can just say two things about this. Oddly enough, I do think there might sometimes be a subjective aspect to the dirty hands problem. If somebody, there's an old saying by Aquinas, I think, when he talks about conscience, that somebody...
I knew you were going to say this.
But I can say it all the same, right? Yeah.
Otherwise, I wouldn't have known it. So make what I thought true. Sure, make what I thought to be true.
Right.
So you knew he was going to say it.
That's right. So if Aquinas asks, what claim does mistaken conscience have on us? And one of the things he says is, well, it doesn't have much of a claim on us because on account of the mistake. But on the other hand, it's a bad thing generally for a human being to act under the heading of evil. It's a bad thing for humans to choose that which they judge to be evil. We shouldn't get into the habit of doing that. Since it presents itself as evil, even though the presentation is a mistake, we are nevertheless proceeding as though we were doing evil. That's how it feels to us. And that feeling, that subjectivity, is itself morally significant, quite apart from the objective truth or falsity of the matter. And I want to say both to Eric and to Francis, I think the phenomenon of dirty hands could partly have an objectively significant subjective aspect to it. An objectively significant subjective aspect to it. It doesn't just evaporate when I am shown to be acting rightly. The phenomenon itself is not, I mean, it isn't itself in the modal or deontic logic. Dirty hands doesn't feature as a value that certain forms of actions have. It's a point about moral phenomenology, and it's a point about morally interesting moral phenomenology, and sometimes it's a point about morally important moral phenomenology. And so everything I wanted to say about dirty hands is in that light, which may well mean that Frances is right when she suggests that there might be dirty hands whatever I do. Yeah? Either I am tormented with the hands soiled by the waterboard, or I am tormented with the hands soiled by the people who were blown up on my watch. And in both senses, the phenomenology will be present, and there is no sense at all into suggesting that its presence on both sides leads to a cancelling out. Its presence on both sides could remain morally significant in each case, and it's worth thinking about. I mean, we could just dismiss the phenomenon whenever it occurs because it has no place in the deontic logic of sort of objective moral analysis. But I really do think that when we talk about dirty hands, we are examining an important aspect of moral phenomenology, and we are trying to assess how important that aspect is. Frances suggested an extremely interesting suggestion that maybe a better analysis of the dirty hands, at least in the classic case, is that even though one doesn't act wrongly, the right action that one does might, in a sense, wrong somebody else, and that hanging on to that sense might partly explain the squeamishness or the sense of soiling. I think that's possibly true in a large number of cases, and probably in any account of the objective moral importance of the subjective experience arises from the fact that we need to understand that it wasn't just an accounting cost that was put on the moral ledger, but there was a human being who was betrayed or a human being who was harmed, and that that might have independent claims on us, even though we are convinced that ultimately it was the right thing to do. But sometimes there'll be dirty hands cases cropping up in cases where nobody's wronged. Yeah? So suddenly, during some terrorist emergency, I have to establish a battle station in the Metropolitan Museum of Art, and all sorts of statues are going to have to be toppled and knocked over and blown up, and all sorts of pictures disfigured, and so on. And I don't want to say one wrongs the pictures. Yeah? And maybe the dirty hands that are experienced in that stage, it was me who tore up that Rembrandt. It was me who toppled that Greek vase. That sense of dirty hands may not be as significant as it is in the wronging cases, but it may be present. So this may indicate to me that there's a more general category involved here. Frances, forgive me, I'm really going to have to think through the lines about symmetry and asymmetry that you gave rise to. I recognize it's an enormously powerful argument. I'm not sure that it amounts to a critique if you would grant what I've just been saying, that the dirty hands phenomenon is a possibly objectively important point about human subjectivity, that formulation that I'm using again. And it may well have aspects of arbitrary privileging on one side rather than the other. That is, the dirty hands problem may seem more arresting, even if there is symmetry. Even if one's going to feel it one way or another, the nature of the action that one is having to perform may mean that one is arrested. One's consciousness is arrested by the sense of soiling on one side or the other. I asked for it, and I asked for a response as complicated and powerful as the one that Frances gave by presenting in the Clay-Cross analysis these nested senses of dirty hands. Yeah? So that on the one hand, there was Crosland would have preferred to dirty his hands in the implementation of the penalties than to dirty his hands with the indemnification of the councilman. So he recognized there were going to be dirty hands on both sides, and the fact was, when he had to act, the arresting sense of dirty handedness might have been asymmetrical, even though there's a certain symmetry involved in the picture. Now, just very briefly on Eric's point, again, I'm enormously grateful for for the analysis. I think it is true that there can be some plurality of the sort that I'm interested in the Machiavelli-type cases, which is not just the plurality of complicity, being on the same team as the prince, but sometimes some of the dilemmas that face the prince have to do with the internal plurality of his regime. He has to torture X in order to get the army to do phi, right? He has to torture one man in order to, or decimate a regiment in order to get it to do something. There are certainly going to be cases like that. And I didn't want to rest anything in particular on the solitude of the prince and the Machiavellian cases. It was kind of just a set up, a provisional contrast in order to get us to focus on the particular plurality dimension that I was really wanting to focus on. Eric asked me to consider the possibility that when we're talking about the legal heritage, the legacy of the law, plurality is not of the essence. What's of the essence is that there has already been action, and it might actually be action. You know, Queen Elizabeth II has given her assent to all sorts of statutes, Labour statutes, Conservative statutes. She's had, whatever it is, 15 different prime ministers. My God, she must feel regret about some of it. And she wears gloves, but it doesn't make it. Even gloves can get corroded over that amount of time. So surely isn't the more general category the category where there has been action already, of which the plurality is just a special case? Well, I mean, I can see no logical difficulty with that position. It's massively unilluminating, because the reality is that in dealing with this question of the legacy of law that we face, we are dealing with very, very large numbers of people. And we are not just dealing with the dynamics of a person of changing their mind over time, which I think are quite different from the dynamics of having to live with another person whose trajectory of mind changing might be different from one's own trajectory of mind changing, and whose trajectory of regret might be different. So from the pragmatic point of view of how best to illuminate the dilemmas of the sort that arise in the Clay-Cross scheme, I think it is better to say these mostly arise in the context of human plurality. Every once in a while you'll have the problem of the sort of single agent regret that Eric mentions, but I think pragmatically that's a special case, even if logically you would do it the other way around. And finally, what's the name of the guy in chapter 42, Naaman? Yes, this is the guy whose master orders him to bow down and worship the statue of Baal or whatever. And,
Rimon.
Forgive me. And Hobbes counsels him, and he himself presents the case to God, saying, "This is not me acting at all." Yeah. Whereupon Eric says, "Then why are you whining about dirty hands?" Right? If it's not you acting at all, why are you whining? But again, we're coming back to the phenomenology of this, that even if in the strict sense and on the analysis that I am giving, the action is not mine, but the action is of an entity that I am personating, still it is juxtaposed with my judgment of the matter. And that juxtaposition is there, even though I don't think the juxtaposition is best dealt with in terms of weighing and balancing. But there is my judgment that, as it were, this organism inhabiting this role was doing something that the organism in other moments would have judged unjust. And that's not going to be able to be dismissed simply by the maneuver, "It wasn't me acting at all." It's just that I think the dirty hands accrue to the individual who inhabits the role. The entity may or may not feel a dirty hands aspect, that is, the polity as a whole, the sovereign as a whole may not feel a dirty hands aspect, although it may, if we go back to the classic cases, if that's what's involved. But the fact is that there is even though there is this personation, which switches our attention away from the individual as individual moral agent to the role inhabitant as personation of the larger entity, even though we've done that switch, even though Naaman has done it in the eyes of God, and in the eyes of Hobbes, which may be even more important, even though the judge does it in the cases that I'm talking about, it's not as though the moral consciousness of the individual in question is effaced, erased, or wholly superseded. It remains present there. And I keep using this language of juxtaposition, which is just a way of saying, let it lie where it lands. Yeah? It's there. It's there. I don't think there's any easy way of integrating it in the simple equation of moral reasoning, of the promise-keeping, helping the stranger type of case. But I think that the phenomenology of dirty hands naturally and understandably crops up there, even though in a strict sense we might say that it wasn't my hands that were acting here at all.
Francis, yes.
I don't know if I have to go sit in the audience and not in order to be recognized again, but I just want to say briefly.
Recognizable.
Am I allowed to? Okay, thank you. Know, Jeremy, I really do think it's important, this issue about the subjective and the objective, because it seems to me that this idea that, well, okay, so I didn't, eating broccoli is not really wrong, but I did it thinking it was wrong. The thing I've done wrong has changed now. The view is that it's wrong then, the second view you're presenting, is the wrong that I've done is to ignore my view that this act was wrong and doing it, okay? It's no longer the question of whether my eating broccoli is wrong. It's whether my acting with the thought that what I'm doing is wrong was wrong. So we're now talking about a different wrong, okay, once we say that this is a phenomenological matter. And I just think that that shouldn't be the problem of dirty hands, the question of, acting when your conscience tells you not to. I don't think that's the important element in the problem of dirty hands. I just want to say I think it's a very important issue, and I'm glad you responded to my point. Thank you.
Let's go to the audience. Tim.
Jeremy, I think there's more continuity between the cases that you described than you seem to suggest. But it seems to me to think clearly about the matter, we've got to come to terms first with what our explanation is of the puzzle that Francis began with. How can it be the case that what I'm doing is right, but it also dirties my hands in doing it? What's the residual? And I want to suggest that the residual lies in the dimension of blame, where blame simply isn't a condemnation of wrongdoing, but something else, some feeling that it's not the same, the way I would put it, our relations with the person aren't the same. So if we're friends, I then perhaps am morally required to do something which harms you or fails to save your child, even if that was the right thing to do, it may be difficult to be friends anymore.
Yes.
That's because being friends involves a certain kind of warmth and concern, which is blocked by this, even if it's right. Now, there are two questions there. One is, can friendship really be a defensible kind of relationship if friendship requires us to do something which is wrong? So we got to square those. But the hypothesis is that the phenomenon of dirty hands rests on the idea that you can square those, but even still have a residual of some want of feeling, and that's where the subjective element comes in, because whether you resent me or feel that our friendship is impaired by my having done this thing that injured you or your child depends a very great deal on how I saw it, whether I did it reluctantly, how I felt about it. So I think if we look at what I'm calling the residual. In terms of this idea of blame or impairment, that explains how a subjective element comes in, but doesn't come in the way that Francis correctly objects to as something that affects the rightness or the wrongness of the action. Now, if we now bring in institutional roles, I can have my relation with you as a friend. I can have my general obligations to everybody as a moral agent, but then I'm also the chairman of the department or the president of the country or whatever, and that involves certain role obligations. And if that role is justified, if we squared these relations, if that role is justified, then I may be required to do things which still put me somehow in tension with something else, particularly with friendship. But I won't go any farther down that road, so I've used up my 15 minutes already. But I'll just suggest that it might be that from the point of view of friendship, one might dirty one's hands simply by taking on an institutional role. Yeah. Because if I take on the role, I can no longer show the kind of concern that normally would be expected of me, even though not that friendship really requires it, but still friendship kind of blocks it. And so what we the case about the council housing, it seems, I think in order to know how we want to feel about that, we have to separate out these two elements. There you have these nested obligations, and that's the question. There's a question of squaring. Does the legal requirement trump the obligation to go along with your party, so we got a whole list of things here, and I think, like the relation between friendship can't require me to do just anything. So I think, and I think we feel some tension in that case because we're maybe some degree unclear about whether what one of these agents did at one of these stages was right. So first thing, get the relationship squared away, which involves deciding whether it's permissible to stand in this relation of loyal party member or and also member of the county council or whatever it is. So we got to square those. Then we can decide what's right, and then maybe we can decide where is there a residual. Is there a residual in the lost compassion of friendship? Is there a residual in the solidarity of fellow union members, which goes beyond it? Maybe we can't be fellow union members in the way that requires this extra dimension of solidarity while also holding public office. Those two might be incompatible with one another. So I just want to suggest if we factor these two questions into these two parts, it might make our thinking about it easier. Thank you.
Can you answer that?
Yes.
Tim, thank you. I do think that's a helpful account of the residual, the business of, well, your role required you to betray your friend, and now you can't look him in the eye, even though you're certain that you did the right thing. It will have maybe the difficulty that I attributed to Francis's account of wronging, that there may be forms of dirty hands that don't involve dissonance with relationship in that way, and we would have to give. But I might never be able to look at a Rembrandt in the eye again, having soiled this particular one for torn it up for bandages. Yes, that's right. That's right. So on the one hand, you talk then, so there's going to be a need for squaring the role that one takes in relation to various relationships or in relation to various other roles that one has. And on the one hand, we want to be able to say that any deep, sophisticated account of friendship ought to be reconcilable with the fact that one friend or the other friend or both may have other roles that have to figure in their action as well. And a real friend would, as it were, shake your hand and look you in the eye after you've just betrayed his kids, because that's what friends do. They recognize that their other friends have careers and so on. And maybe in some sort of tidy ideal, that's the way it would work. I think the dirty hand sense comes from the fact that the roles and relationships, in fact, jar jaggedly up against one another and have aspects of dissonance. And each one is perhaps more demanding than it ought to be in this ideal, tidy world. And that's going to be a major source of the residual that you're talking about. I think in the Crosland case, it's extremely interesting. I mean, he's thinking he's committed by his party to do this distasteful act of acting against the rule of law. And he might think, how can he ever look the people in the eye and talk about the rule of law again? And again, there's that sort of residual going on, which is itself a relationship idea. Thank you.
Show reluctance when you do a dirty trick. That's in Aristotle. Yes.
I just wondered how far you want to push the double consciousness idea, in particular thinking of the role of citizenship, or of a citizen. And this is evoked by the mention of Nazi Germany, or any place you want. You play a role as a citizen, presumably. It's a role that's a little harder to step out of, even if you don't participate, because then you're making an act anyway. So now it seems like an implication of your view would be that insofar as you are occupying the role of citizen, there's a consciousness that goes with that that's separate from your consciousness outside that role, from your role as an ordinary person in some way. So I'm just curious if you want to push to that level or not, because it's the distinctive thing about being a citizen, as I said, is that it's a little harder to exit it. Even all the acts of exit are political in the same way. So, so I'm just curious as to, and whether this just transforms all of morality, incidentally. So.
Right. I mean, there are people whose approach to these dilemmas as citizens, this is something that Ronnie Dworkin talks a little bit about when he's introducing the idea of integrity in Law's Empire. There are people whose approach to citizenship is to put a bumper sticker on their car saying, "Don't blame me, I voted for McCain," or "Don't blame me, I voted for Obama," so that they're hedging their bets and making sure it's well known that whatever is done is not in my name. And like Ronnie, I'm rather skeptical of that approach to citizenship. Citizenship is a sort of a minimal office. And when war is waged in Iraq or in Vietnam, I have the satisfaction of being able to say this, one of the few advantages of not being an American citizen. All of that was done in your name, yeah, each one of you, yeah. And although that doesn't mean to say that you all go on trial for it, because we shouldn't have a theory of culpability that attaches to the minimal role of citizenship, I certainly do want to push this double consciousness far enough to say that each citizen should feel some complicity or some implication in the decisions of the polity in which they live, even though it was a decision made that they voted against, or voted against the person who made it, and so on. And I think if you push it that way, it's much easier to develop a proper sense of where we really do want citizens' civic duties to bite, and where we really do want citizens' civic duties to do some work, than if you begin by saying, no, people are first and foremost moral individuals, and you can only reach their civic obligations by various convolutions or various special circumstances.
This was also a question about the role of the citizen, but perhaps, thank you, perhaps we can root it not in Aristotle, but in the Crito, because I was thinking as you spoke about the laws of Athens addressing Socrates and saying, as a citizen, you have the obligation to accept the death sentence on yourself. So you're not now acting as an agent. You're not a law officer enforcing the law on someone else, but you, as a citizen, have the obligation even to accept this. And so in a way, it follows John's question. I wanted to ask, what's special then about the role of the law officer, if even one might think the ordinary citizen has the same kind of duty to accept and enforce the rule of law? Is there really a special distinction for these roles?
I think in principle, and in illuminating principle, the answer is no. Most of the laws, as we know them, are administered not by law officers, but by thousands, millions of acts of self-application. Self-application, a much underrated idea, but massively important in a rule of law state. So, when you drive, you are self-applying the laws, you are monitoring your conduct, you are moderating your conduct by reference to an internalized set of public norms that you've taken on board. And that the law should be such that it can be self-administered in this way is massively important. Now, we don't actually have self-administration of penalties, except that people may be sentenced to a term of years in federal prison and required to turn up in 6 weeks and surrender themselves at the gates of the prison for their incarceration. And 98% of them do, and the other 2% run away. And there are some laws that can't be self-applied, so you can't self-apply divorce law. You have to get a law officer to make a determination that you are divorced. So self-application is hugely important, I think. The task of the law officers is to supervise those cases where self-application by ordinary citizens is not enough, or where self-application by ordinary citizens has to be corrected or second-guessed. And so they have, as it were, a backup role. But I found in my own work on the rule of law that meditating and thinking about this business of self-application and what it involves, and in some sense the dignity of the self-application of rules that have been enacted in your name by a community of which you are a member, is a very, very important idea. So without saying anything about the justice or the injustice of the Socratic situation in the Crito, I would be willing to go that far. On the other hand, when Socrates was instructed by the 30 tyrants to go and unjustly arrest a general or an admiral, I forget which, what did he do? He just walked away. And the difference between the two was it's better to suffer wrong, or it's worse to do wrong than to suffer wrong. And so that was
Richard.
I just really want to make 2 points. I want to come back, first of all, to the issue that Eric picked up about the question of the relationship between a modern politician and the enormous mass of obsolete and ancient law that is still on the statute book. And the point there I just wanted to make is that I think there's a very general problem about this, which, as you know, a lot of people have tried to understand what it is which gives these extremely ancient laws authority. And one answer, although it's not a very fashionable answer at the moment, but it was an answer that people put forward for a very long time, is that they have authority by virtue of not being repealed by the current legislative sovereign. And of course, if you take that view, then what you were saying about the complexity of our relationship with these previous legislators would no longer be applicable, because it's only, so to speak, a relationship within the current legislature. And as I said, this has become a rather unfashionable view, and Hart, in the concept of law, leveled some arguments against it, which I must say I've never entirely understood or seen as particularly convincing. And it's not an unreasonable first go at this question. So I suspect that taking this example may actually confuse the issue, because depending on what position we take about why, the Act of Settlement passed by a gang of crazed Protestants in a semi-representative assembly still actually controls the dissent of the Crown of England, depending on what answer we give to that, I think we may take a different view from the view that you put forward. And the second point actually is just, as you would expect, a point about the interpretation of Hobbes. I think actually the case of Naaman is more complicated, because Hobbes actually has a long theory about why, at least for Jews and Christians, we extend the same relationship to our sovereign God as we do to our civil sovereign, except the sovereign God is the higher sovereign, and the civil sovereign is in these cases a vicegerent, as he says. So I'm not sure that this is actually a case of sort of inwardness at all. Right. It's a case of, do I obey the governor of Massachusetts in colonial days, or do I obey the King of England?
Right. So we're going to get problems replicating themselves at that level for poor old Abraham, who has to sacrifice Isaac. And we have to, again, analyze the phenomenology of that as carefully as Kierkegaard did, and so on. But listen, on this other point, that some ancient statute has not been repealed is certainly a condition of its authority among us now. I think it is preposterous, forgive me, to say that it's the basis of its authority among us, because the thing has authority among us even if we haven't had an opportunity to repeal it. So on day one, we've barely been able to assemble the new parliament, but the Housing Finance Act still applies, and the penalties continue to accrue. So I agree with you, it's a problem about what is the basis of the ancient laws. Remember, it's not just ancient laws, it's ancient, relatively recent, 1930s, and so on. So it's a Social Security Act as well as the Act of Settlement. But I don't think it's going to be plausible. It's a very Hobbesian move. Hobbes says, what's the authority of the common law? The authority of the common law is the consent of the sovereign. How do we know? Because he hasn't overruled the judges. And it's a maneuver rather than a theory. But as I say, it's a condition of authority, but it can't be the basis of authority.
I agree with you, but I think it's a problem. I don't know of any very good account of what it is that gives these, as I said, obsolete acts passed by people whose views we would completely regard as ridiculous now. Still has authority over us. I think it's a deeper problem than many people acknowledge.
I think it is a deeper problem than many people have acknowledged. I think one has to work at it at the other end, that part of the momentousness of passing a law is that one is not just winning a particular conflict now, but one is establishing oneself as a victor in a particular set of conflicts that will recur until repeal takes place, decades and centuries after what we're doing, which is why we need to be that much more careful in legislating, because what we are doing is asserting an authority on the basis of a present majority, an authority to bind future parliaments or future congresses as well. I would work at it from that end rather than working at it from the momentary tacit consent of those who haven't gotten around to repealing a given statute.
Question over here.
I wonder if the panel could discuss the relationship between dirty hands and the wonderful discussion yesterday about dependency corruption. So it's one thing to talk about representatives not only representing their own interests, but also those of their constituents. It's another thing to talk about their representing silent funders in disguise on whom they depend for raising, to take Larry's figure in his book, $30,000 each and every week. And then those funders also couching their interests in disguise. And as he said, the Lesters in Lesterland are using their funds to pursue their own interests. So do we now have corroding hands? What does dirty hand, it seems to me this fundamentally changes a number of the lines of argument philosophically if one's talking about dirty hands in a dependency corruption.
I mean, I have always thought that the two problems were relatively separate, although they both involve elements of soiling. Corruption has a sort of soiling element to it, dirty hands obviously. There's certainly going to be some potential for dirty hands simply in the act of representation, yes, and because one will sometimes have to represent interests. One can't always be Edmund Burke. I know John Fairjohn is going to speak a little bit about this. One can't always be Edmund Burke. Sometimes one has to make sure that one is the conduit by which a certain set of interests or even a certain set of opinions are brought into the process of deliberation. It's a point generally about the independence thesis, about political deliberation, that although it's absolutely right that bills and proposals should be evaluated by legislators upon their merits as possible contributions to the general good, possible implementations of social justice. One of the reasons why we assemble very, very large numbers of people in our legislators is because we are confident we can't have the right amount of input if there are only 7 or 8 people in the legislature. We really do need 435 in the House and another 100 in the Senate, because we think that there is a diversity of interests in the country which will not be known in Washington by magic, but will only be known by somebody coming and bringing them in which case we're going to be very, very careful about the idea that legislators should not regard themselves as any sort of conduit for special interests. They sometimes have to be a conduit for partial interests, because unless we hear from the representative of the lobstermen in Maine about the implications of the law of the sea treaty, we won't have the basis for a full public good account of the law of the sea treaty. So this is slightly orthogonal to the question you asked, but I think it's an important corrective that we understand a legislature as a place where information about interests and where different voices are accumulated in ways that won't happen by magic except through some process of representation. And it necessarily requires that each legislature will be, in a certain sense, representing partial interests in the interest that they bring into the assembly.
Well, we know it's much more pervasively bad than that. We know that the defense industry pays heavily, the committees in the Senate and the House, and we even go to war for the sake of keeping sales up. And then that's done in the name of, national defense.
Yes.
And there are many other such examples.
No, I didn't want at all to imply that that wasn't the case, and I join with you in condemning the corruption on which that is sometimes dependent. I'm not sure that the sort of analysis that was being essayed here this morning casts as much light on that as Gary's analysis did, as Larry's analysis did yesterday.
I think you addressed your question to the panel, so I don't know if Eric had. But, one thing that strikes me is, it's just a partial view and an immediate response, is that when you see an improper dependence, as Larry would say, rather than a proper dependence, you first ought to think whether this is not an instance of someone in their role as a legislator getting their hands dirty for the greater good. So in other words, if there is an improper dependence relationship, it may be that the individual is thinking, if I don't do this, the greater evil will occur, okay? And maybe this is in part when Professor Shepsley, was speaking, you've got to see what would have happened, counterfactually in a sense, if they hadn't done this, okay? So all I'm saying is that the first thing that strikes me is that this is an aspect of it. Okay, you've located an improper dependence, okay? Find out why it was engaged in, why this improper dependence took place. And if there would have been a greater violation either of individual or role obligations as the agent of the people, all right, if this hadn't occurred, you may take a different view of it. That's just an immediate response about the relevance of this.
Well, as I understand what Larry's saying, it's improper dependence all the way around.
Yes.
And structurally and institutionally, it's pervasive all the way around. It's not as if one
Right. I mean, if it's totally the improper right, that's so. But I'm just saying that in some cases, when you locate it, you've got to situate it. You've got to see what the alternatives would have been, at least if you take seriously this idea of lesser and greater evils, and sometimes it is not wrong to do the act that would have prima facie been wrong had there not been justification.
Larry, you want to talk about?
So I'm not going to take the opportunity to follow up. I want to burden you with your position in a law school to relate your analysis to a pretty important moment in the development of constitutional history. So to the extent you're describing, in a sense, the separation of the moral conundrum of the individual and the conundrum of serving in a role, I was reminded of Marshall's analysis in Marbury versus Madison, where part of the reasoning, part of the logic of the argument turned on the fact that if the alternative conclusion followed, the individual would be forced to engage in what was for that individual an immoral act. So I swear to uphold the Constitution. As a judge, I swear to uphold the Constitution. But if I'm not allowed to then interpret the meaning of the Constitution, then I will be violating my personal oath to God. So I'm not allowed at that point to say, I'm just a judge, I'm just doing what my role as a judge says. Marshall is in fact saying it's because you have this personal morality that we have to understand the role morality difference. So I wonder how that relates to the argument you were advancing.
Thank you, Gary. I mean, I think it's extremely interesting. I think the oath in that circumstance and in many other circumstances, such as the juror's oath to hear the case impartially and so on, represents a way of binding the individual considered as moral agent. In the old account of oath-taking, you're binding the immortality of your soul to the scrupulousness with which you will pursue and perform the role. So you are doing something like saying, not only will I take on this role, so help me God, but I will not step away from it until I have completed it, so help me God, and I'll resist any temptation to step back into the other role. So it's a marker, and it's an individual moral undertaking in relation to role. It recognizes the possible difficulty of bridging the two persona in this picture. So I think it's extremely interesting, because I didn't ever want to deny that there is, of course, an individual moral dimension in actually stepping into role, taking on the burden of the role, and maintaining the discipline that imposes on thinking, which after all is going on inside the head of this flesh and blood individual. So I think the oath does, in the days when oaths used to be taken seriously, it does immense work.
Eric.
Since reading Francis's paper years ago on collaboration, I've doubted dirty hands as a phenomenon. It seems like it could be explained away by agent regret phenomenologically, but not. But we're left with something like Dennis's version of it, the democratic version. But in your paper, Jeremy, I think I see space for a position that comes out. Imagine an agent who has places special weight on their own doings. That kind of deontic agent that we know. Maybe you want to call them morally self-indulgent. But that person, when they enter the office, in particular when they take the oath, what they're acknowledging is that they will no longer place that extra weight on their doings. Now what we're left with is still they place weight on their doings. So they're not actually going as far as you and not acting in that role. It's their action, but now that action gets placed on a plane with others. And that to me seems to be a stable foothold for a real phenomenon. You might want to go farther, but I find it to, at least the phenomenon of dirty hands could exist for an agent of that kind.
Yes. No, I think I accept that entirely. I mean, maybe I do want to go further in certain formulations, but that's the basic structure of the view. It's partly what I meant by juxtaposition, that is, and it really is a problem of double consciousness.
Well, thank you, everybody. It's time for lunch and time to thank our panel.
Thank you very much.